Right. And I'll just do my big disclaimer.
Oh, good. You do your disclaimer.
Which essentially is that I'm not providing any legal advice this evening. So everything is for informational purposes only, and none of this creates an attorney-client relationship. Meaning that if you something, and I would caution for what you say, this fortunately is not a criminal law Q&A. So, but just keep in mind, nothing is covered by attorney-client privilege on this. So if somebody were to say, by the way, I was the person who robbed the bank in town yesterday, keep in mind, because you're addressing that question to me, since everybody else is on the Zoom, that is not considered confidential. And I know that sounds silly, but I'm legally supposed to tell everybody that. But again, feel free to ask questions, but just know that I'm not allowed to give any specific advice. I can give overall advice, an overview. But feel free, you can always call my office if you have particular questions, or like Beth said, if you're really uncomfortable asking a question, feel free to give Beth or myself a call.
As I've always told you in all of our webinars and seminars, that everybody's different. All the information you're getting is general. And if it sounds informative, if it sounds like something you might think is good for you, then please give me a call. You can also give Courtney a call, but please give me a call, because again, just like what Courtney said, unless we know who you are, and unless Courtney knows who you are, there is absolutely no way to know what's right for you. So when we're talking about probate and when we're talking about trust, it's general rules that may or may not apply to you. So now I'm going to stop sharing my screen. Whoops. Stop sharing my screen. And here we all are. And I'm going to introduce Courtney to you. And inside of Courtney, we gave you an email that gave you Courtney's bio. So I'm not going to read Courtney's bio. What I'm going to tell you is that Courtney and I met many, many, many moons ago, but Courtney's much younger. Yeah, in the Rockland Business Women's Networking Organization. And back then, I was very impressed with Courtney and how she practiced estate law. And although Courtney isn't the only estate law attorney I use, she is the only female estate law attorney I use. And I have a couple of other very, very good estate law attorneys, but I am very pleased with Courtney and her advice. So I asked her to come and help us go over some of the principles of estate planning, because I will tell you that almost always, when a client comes to Eastern Planning as a new client, and I say, let's look at your legal documents, they are old. Some people get referred to us by estate attorneys, so they have nice, fresh, new legal documents. But on the whole, they are old. So legal documents is something that people tend to do, put in a drawer, and forget about. So today we're going to have conversations with Courtney to understand how long you should keep your documents in a drawer and what are some of the considerations you need to think about. So before I start asking my questions to Courtney, I wanted to give Courtney an opportunity to just have a little conversation with us and discuss just who she is without bragging.
Well, and some of you I know, some of the names and faces look familiar, but I'm Courtney Boniface. I'm a partner with Kane and Boniface, and we only do estate planning and settling estates. We're based out of Nyack, New York, but I'm licensed in New York, New Jersey, and Connecticut. So we tend to help people within the tri-state area. And like I said, this is all we focus on. So if you said to me, hey, I'm selling my house, the market's hot, can you represent me to sell the house? I would say no, but I have a couple of good names I can give you. This is really all that we do every day. And like I think, Beth, I met you 21 years ago now. And I started doing this the first day I started law school. So this is the only type of law I have practiced literally since day one. And we're a small all-female practice. Barbara Kane started the firm in the early 90s. She's what we call semi-retired, which means right now she's enjoying a much warmer climate than we are. And we have another full-time attorney, Stephanie Zacharias, who is wonderful and knowledgeable, and she's licensed in New York and Florida. So she's great for our snowbirds, a lot of clients who have property and spend time in Florida as well. And that's about it. You can certainly learn more about our office. You can go to caneboniface.com, and that's CANE Boniface.com. And there's lots of information there, some articles and information about the.
Okay. So as I said, what this is more of an understanding of some general principles that happen to be asked by clients when they come into my office. And one of the biggest things is when people write a will, they make the word will equal estate. And they make the assumption that what their will says is what will happen. And that's not true. And one of the conversations is, what does a will cover? And a will covers your probatable estate. And so one of the questions I have with Courtney is, when you write wills, how do you explain what a probatable estate is as compared to believing that your whole estate is part of your will?
Okay, so first of all, when we sit down with clients, especially for the first time, we send out a questionnaire. We ask clients to tell us about all of their assets. And it's not because we're being nosy, but a will doesn't cover everything. A will is actually sort of the last document that controls your estate. So we want to look at the type of assets you own, how you own them, and about what they're worth. And the worth part, that's dealing with estate taxes, which we may allude to in a little bit. But really, the type of asset you own and how you own it are so important, because not everything passes through your will. And there are assets we don't ever want to pass through your will because there's negative tax consequences. So sometimes clients will show us a will or show Beth their will, and then we'll say, okay, this is a very nice 10, 15, 50-page document, but it's not going to do anything for your estate. And the reason is because if you own joint assets, that doesn't pass through your will. It passes to the joint account holder. So if you have a bank account with your son or your daughter and you pass away, it's going 100% to that son or daughter, not the 3 other children you may have. Life insurance will pass by beneficiary designation. It's who you filled out on the form when you bought the life insurance, or maybe you updated it over time. But if you have beneficiaries on that life insurance, again, it's not passing through your will, it's going by beneficiary designation. The same with transfer on death, payable on death accounts. Those are accounts like your brokerage type accounts that have a beneficiary on it. And sometimes it makes good sense to name a beneficiary, and sometimes it doesn't. And it really depends on the situation. And then we have your retirement assets, your 401ks, 403bs, traditional IRAs, any type of tax deferred account. We never want those to pass according to your will. We always want you to have beneficiary designations on those accounts, and that's for the income tax reasons on those. So your will, in the end of the day, your will only controls the assets that have no one else named on there as an owner and don't have a beneficiary. So typically that's like your house. If you're not married and you own the house in your own name, that will pass through your will. If you have bank accounts and they're just in your name, or you have an account with Beth and it's just in your name and there's no beneficiary, those will end up passing by your will. And a lot of times people just assume, well, I'll throw beneficiaries on everything and then I won't have to go through. And we'll get to probate in a moment, but essentially that's not always such a great thing either, because you may end up naming minors as a beneficiary, and minors can't own property. So that creates a whole new reason to go into court.
And they can't have investments.
Right. So if you name a minor as a beneficiary on an account, now the parent has to go into court, be appointed as the guardian. And like Beth said, the court doesn't like a minor to own anything that might go down in value. So they would say, okay, we're going to appoint mom or dad as the guardian, but they have to keep this in a checking or a savings account. They can't leave it in an investment account that's going to grow. And
Or
by
a
the way,
529 plan.
or a 529 plan. And by the way, mom or dad, they have to post a bond every year on that account, because we don't trust mom or dad with the money. Sometimes they shouldn't be trusted with the money, but in most cases, it was just because, maybe grandma or grandpa didn't realize naming a minor on an account was such a bad thing. Naming a disabled beneficiary is never a good thing. Somebody who has creditors. You may name all three of your children as payable on death on an account, but God forbid one of those children predeceases you. Well, now it's only going to your two kids, not your grandchildren from the child who predeceased. So that's why whenever we're looking to do an estate plan, we want to look at the full picture, everything you own, how you own it, whether or not you have beneficiaries, and whether or not you should have beneficiaries on there. And that's why, if you go to an attorney and they don't ask you for information about what you own, you should walk right out the door, because then you're just getting a document that's a couple of pieces of paper that typically is not a good estate plan and will just cause more problems than they'll solve.
But you mentioned probate, and you said that sometimes we want to go through probate. And a good example of wanting to go through probate is when you do have minor children and you want the assets to go into a trust for the children, and the trust is in the will. So you don't name the children, you want to name the trust. But what is probate? How do you get probate? How do you even get that to happen?
Right. So probate, technically, it comes from the word probare, the Latin word probare, which is to prove. And it's essentially the process of proving that a will is the valid instrument and getting the executors and, if needed, the trustees formally appointed by the judge. And in most cases, a lot of it depends on where you live. But if you're in the Rockland, Westchester, Orange area, even Bergen County, probate for most people is not all that difficult. It's become more time consuming. So when I first started this 20 years ago, we could file a probate petition on Monday and have what's called letters testamentary, meaning that the will was probated by Friday. Now, especially with COVID, it's taking about 6 to 12 weeks, but essentially it's a process. It's red tape administrative process through the court system where the will is presented to the judge along with a petition, and it's all the information is out there. Who's named in the will, who would have inherited if that will didn't exist, what assets are passing through the will, information about the witnesses and whatnot. And if you have a very straightforward estate, probate is usually, it's pesky, it's time consuming, it's usually okay. But there are times that we really want to avoid probate. You want to avoid probate if you live in one of the 5 boroughs. Probate can take a very long time, and part of that is just court delays and court backups. So probating a will in, say, New York City or Queens has become very time consuming because they're probating a lot more estates than they are in the Rockland County Surrogates Court. So while something may take about 6 weeks in Rockland, it could take 6 months in New York City sometimes. So it just takes a lot longer, and it's harder to get through to the court and get somebody on the phone. But it's important to keep in mind, a lot of people think, but my mom had a will. Why do I have to go through probate? I can't believe this. That attorney was a nincompoop. Now we have to probate the will. A will always needs to be probated if it needs to be used. So that's something you want to always be prepared for, that if somebody has a will and assets pass through it, nothing can be done with those assets until the will is probated. So they're literally frozen, that nobody can sell a house if it has to be probated until that executor is appointed. If there's a brokerage account with Eastern Planning, Beth can't distribute that money. She can't pay bills from that money for you. She can't reallocate the assets until the executor is appointed. And this was a big problem back last spring when the courts were closed because of COVID. So for those estates where somebody died during that period or just before the courts shut down, if the executor hadn't yet been appointed, we were at a standstill. There was no getting an emergency executor appointed because, especially like in Rockland, the courts weren't even opening mail. They didn't open mail for about 8 weeks. So there is an advantage to avoiding probate, and we'll talk about that in a moment. But all in all, probate is essentially proving that the will is a valid instrument. And this is where it becomes really important when you sit down with your advisors, whether it's somebody like Beth or somebody like me, to put all the information about the family out there, because that helps us determine, do we really want to avoid probate? And you want to avoid probate when you want people to have immediate access to your assets. If you own property in more than one state, so if your primary residence is New York, but you have a winter home down in Florida, or a ski cabin in Vermont, or something down at the shore or the Cape, then you have to probate in every single state where you have a piece of real property. And that can get expensive because now you need multiple attorneys, there's multiple court fees. So we always look at, when a client comes in, oh, you own property outside of New York or whatever your home state is. We usually suggest a trust to avoid having to probate in all of those states. If you're disinheriting somebody, you want to avoid probate, because now when people are sort of shocked to find that when we go through probate, if somebody's disinherited, let's say their son or daughter, or if they don't have children, maybe they've disinherited a sibling or a niece or nephew, that in New York, in order to probate that will, we have to contact the people who would have inherited had that will never existed. And in order to go forward, we need that person to sign what's called a waiver and consent. And it's probably doesn't come as a shock to you, but if you're disinheriting somebody, they're not so willing to sign this waiver and consent. The question usually is, what's in it for me? What are you going to give me if I sign this piece of paper? And we can't go forward with the probate until that person has either had their chance to have their say in court or they've signed this document. So whenever somebody is disinheriting somebody, we always say, let's try to avoid probate. Nowadays, if there's a lot of minors involved or disabled beneficiaries, people who can't sign waivers, the courts are starting to appoint what's called guardian ad litems for these individuals, which essentially means the court is appointing another attorney to represent the interests of the minors or the disabled beneficiaries. So now that's a second set of legal fees to pay, and it can really slow things down. And we have a case in Staten Island at the moment where we didn't do the planning, but we're representing the executor, and her dad disinherited her brother. And he died first, but left behind a minor child. So now the court appointed an attorney for this minor child who would have inherited through her father. But basically, we're calling it the Staten Island shakedown, because essentially this lawyer for the minor, for this 9-year-old, has said, what are you going to give us? Otherwise, we're contesting this whole thing. And we can't go forward. We're sort of stuck going forward. And now we're sort of negotiating a settlement simply because we have to go through probate and we can't get through to the next phase until we have some sort of agreement there. So, disabled and minor beneficiaries are good reasons sometimes to avoid probate.
Before we talk about how do we avoid probate and trust, I have another will question, which could also be a will and a trust question. But the question is, how long does a will stay in effect? And there are reasons for updating a will. And I will tell you that today I had a conversation with a client and we had a reason for updating a will, a spouse's will, because the mother's will, because the father is suffering from Parkinson and getting much worse. And we had to update the mother's will to get the father out of the will and make sure there was a trust for the father. And it's so much more complicated than that, because like we talked about what's part of a will and what isn't. We had to change beneficiary designations. We had to change ownership. So we had to make the joint account now an individual account. So we had a lot of work that we're doing and have to do. But so there are times when we know we need to change the will.
Right.
But how do we know if that's not such an obvious time?
Obvious time, right. And wills, technically, if a will is if you sign it and it's valid when you sign it, it's still technically legal until you pass away or until you revoke it. But older wills can be really problematic sometimes when we're trying to go through probate, and especially wills from the early 1990s and before that, because in about 1992, we got what's called a self-proving affidavit, which is a document that the witnesses sign at the time they sign the will. And they basically say, I swear I saw Beth sign her will and she appeared to be of sound mind and she looked like she was over the age of 18. And everything, I signed, she signed, the other witness signed, everything was all good. So that when we have to probate the will, hopefully many, many years later, we don't have to track down these witnesses. So one of the first things I do is when somebody sends me their will to review, I immediately go to that back page and I look to see how old the will is and did the witnesses sign this document? Because if it doesn't have a self-proving affidavit, we usually want to update it completely, because finding witnesses 20, 30, 40, 50 years from now can be impossible. And the court doesn't just say, oh, well, these witnesses are probably dead, let's go forward. It's a whole process, and that can really slow down probate and make it more expensive than it would be to just create a new will. But other wills, other reasons, life changes, laws change, your beneficiaries get older. You may not want the same beneficiaries. You may look at your will and say, oh my gosh, I can't believe I was giving this to my brother, my sister, my friend. I don't talk to this person anymore, or they just won the lottery. They don't need my money anymore. I want to change that. So if you have a change in beneficiaries, if you get married, you get divorced, you have a beneficiary maybe who has creditors, who is now disabled. Maybe they're getting divorced. They're bad with money. Or maybe they were so good with money that they have tax issues of their own, or they don't need your money anymore. If you have a will, sometimes we look at wills and I look in here and I say, how old are your children? Well, they're in their 40s, but the will still names guardians for the children. Then we know it's time to update this document. It's still valid. It just doesn't make good sense anymore. If you move to another state, now granted, if you signed your will, whatever state you sign your will in, it's still valid whatever state you go to, but it may not make good sense. Rules are different between states, tax rules are different. So you always want to have a local attorney review the document. Another reason to change your will would be your assets have changed, and that's for better or for worse. If you did a will when you were newly married and you were having kids, taxes were probably not an issue. But over time, as you build up your estate, we may want to update that.
And everybody forgets when they talk about assets, they always go, oh, but assets are so high and I don't have to worry. And especially for younger people, when they have a couple of $1 million of life insurance, they tend to forget the life insurance portion of their assets that will be an asset in their estate at their death. They tend to forget that number.
Right. And sometimes another reason people want to update their documents is they were giving everything to their 3 wonderful children, but now maybe 1 or more of those children, maybe they're not so wonderful anymore, or maybe they're not so happy about who those wonderful children married. And they say, I wouldn't want my daughter-in-law, my son-in-law to get any of this. So those are always good reasons. But, you know, I always say, if it's been, I like to say, take out your documents. Now that we have phones, we can put calendars on reminding us, just put a date in there every year to pull it out. But at least every 5 years, take a look at it. And then have it reviewed at least every 10 years, you know, by someone professionally who can look at it and say, you're good, you're fine, everything's good to go, or gee, you know, it's time to make some changes. It's not a one-time and you're done type of document.
We talked about the beneficiaries, but it's more than just who did you name beneficiaries. It's also who did you name executor or contingent, and who did you name trustee? And all of a sudden you say, what was I thinking when I named that person my contingent executor or executrix? And you have to look at all the other names that you put into place in your
Right, absolutely. Pretty much if there's any name in there that you look at and you say, what was I thinking? It's time to have a redo. And a lot of times, especially if you do it when your kids are on the younger side, you may have named your brothers, your sisters, your friends as executors and trustees, but now your children are old enough to sort of do all of the work. And a lot of times the children would prefer to do the work than have their aunt or uncle tell them, you know, who gets the silverware and who gets, you know, when the house will be sold and whatnot. So that's always a good reason as your kids age.
Now let's get back to the trust. So you gave us a couple of reasons why it wouldn't be good to go through probate, and it isn't good to have a will. So now everybody hears trust, and most of the time what we're talking about is revocable living trust as compared to irrevocable trust. So can you just explain to us what a revocable trust is? And again, why would you consider having it a trust as compared to a will?
Okay, so a revocable living trust, it's living because you create it while you're alive. It's revocable because you can change it at any time. So you can change the terms, you can get rid of the trust completely if you want to, but every time you want to make a change to it, you're allowed to, as opposed to irrevocable, which means once you set that language in stone, it's in stone permanently. But a revocable trust is a way that people will put together their estate plan instead of having a will-based plan, ineffective to bypass probate. If they say, probate was a pain in the neck when we did it, and I want it to be super easy for my children or my beneficiaries. I don't want them to have to go through the court system. I don't want assets to be frozen. And I'm just sort of going to grab a little bit of a prop here. But if you think of this cup as your revocable trust. So if we said, we're creating a revocable trust for Beth Blecker today, she would then, and I have my trivia packets here, but she would put her house in the trust. She would put her non-IRA brokerage accounts in the trust. She would put her bank accounts in the trust, and she would fill it up with all of her non-retirement assets.
And remember that word, non-retirement assets. Do not put your IRAs or your 401ks or your 403bs in a trust. You can make the trust the beneficiary, but you cannot title it the trust.
Right. So in here, let's say we have Beth's house in West Nyack, and Beth passes away. Now her kids can come in as the trustees. They don't have to go through probate for that house. So they can, even the very next day, essentially sell that house and split the money, or they can split it between the two of them. They can say, okay, Matthew, you get the house, and Jackie, you get other assets. They don't have to wait until probate is done in order to access those assets. So it speeds up the settling of the estate, avoids that red tape in court. And that's especially good when you have people who may contest your plan, somebody who may say, what are you going to give me in order to sign this piece of paper? But it's also helpful when you own, so if Beth had her West Nyack house, and I'm making up all this information about Beth, and now, a ski house in Colorado. Now they're both in the trust. It means we don't have to go through probate in Colorado, and we don't have to do probate in New York. And if she 5 years from now says, you know what, I don't want Matthew to have the house, I want Jacqueline to have the house, she can make those changes. If she says, I want to sell the house and I want to take the money and put it on Red 31 in Vegas, I'd say, well, I don't think the Red 31 in Vegas is such a good idea, but you can certainly sell the house, buy something else. You can do whatever you want to do with the money, just like you could today, except anything that's in this trust vehicle when you pass away avoids probate. But when you have a revocable trust, you always want to have a bit of a catch basin underneath. And what this is let's say, oops, Beth forgot to put that one bank account into the trust. The bank account will hit her will, and the will is a pour over will. It simply says, anything I forgot to put in my trust, pour it over into the trust now. That would have to go through probate, but just that bank account. So her kids would have access to everything in the trust, and we would do probate there. The goal is, this is I either say this is the cup and the saucer, or this is the catch basin. The goal is to never use that will. It's there as a safety net. And just like the trapeze artist never really wants to use the safety net, we don't want to have to use the will, but it's there just in case. The nice part, one of the really nice things I like about the revocable trust is beyond the probate avoidance. If Beth said, I love my son and daughter, but they're either, I want the money to stay in my family tree, or, my kids have done so well, I want it just to go down to my grandkids, but we need trusts. When you're creating trusts for other people, your beneficiaries, if you do it through the will, every time you want to change a trustee down the road, you have to go back to the court to do that under a will. When you do it through a trust, the trustee with about a page or a page and a half of paperwork, we can move around trustees for your kids or other beneficiaries without having to go back to court. And over time, that can be a huge savings. So just to give you an example, we have an estate we're working on. I feel like we've been working on it for years, but essentially the grandmother created a trust for her daughter. The daughter died at 95. And now we have to go back into court. We not only had to probate the daughter's estate, we had to go back into New York City courts, reopen grandma's estate from the 60s in order to appoint new trustees for the grandkids. Whereas if grandma had done that through a trust, that would have been maybe an hour-long process of doing paperwork, signing it, and being done. Yet here we are a year and a half later, and the New York City court just hasn't gotten to that file yet. So that if you're creating trust that will be generational or for the long haul, doing it through a revocable trust makes good sense.
And then the final piece of trust is there are people who say, but I'm told that if I put everything in an irrevocable trust, I'm going to avoid I'm going to be allowed to go on Medicaid and avoid having the government take all of my assets. And I want to do an irrevocable trust. So explain what an irrevocable trust is. And I will also tell you on the financial planning side that people's biggest assets used to be their house, and now it's not. Now it's typically their retirement plan. And again, you do not put a retirement plan in a trust, revocable or irrevocable, unless you want to take it out of the plan and pay lots and lots and lots and lots and lots of taxes first. So right. Now we can talk about an irrevocable trust.
Sure. So an irrevocable trust, and let me just say, when we talk about trusts, there are hundreds of different types of trusts for so many different reasons. But for tonight, we're talking about the revocable, where you maintain control. And if you want to use the money and go to Vegas, it's yours. But then there's the irrevocable trust that a lot of times, there's several types of irrevocable, but what we're talking about tonight is when people want to use an irrevocable trust because I'm afraid I might need to go into a nursing home or need long-term care. And what the question we usually get, or the statement we usually get, is they're going to take all of my money. The government's going to take the money. And what I usually say is, well, the government's not taking the money. You're spending the money on your care. You're paying the nursing home or the aides to come in. But essentially, Medicaid, it's part of the welfare system. So essentially, they say, we're not going to pay for your care. We're not going to pay for you to be in a nursing home when you have money in a revocable trust or you have access to everything. You know, if you can use the money to buy a new car or go out to dinner, basically the government says you should be using that money to pay for your care. When you put it in an irrevocable trust, the goal is you want to do that 5 years before you're ever going to need Medicaid. Because right now there's a 5-year look back period, meaning that if you pass away, if you need to apply for Medicaid, they will look back right now for 5 years. They will literally look at everything. They want to see your bank statements, your financial statements, your retirement statements, your social security statements, your income taxes. And they're going to go through and they're going to say, well, what was this big chunk of money transferred for? What was that done? But they only look back for the 5 years. So if you put assets into an irrevocable trust and you don't apply for 5 years, if you then spend down your other assets, you might be eligible for Medicaid. The key here, though, it's irrevocable, that you can't say, well, I want to use that money for vacation. I want to use that money to buy a new car or to buy presents for people for the holidays. It's irrevocable. You are no longer in control of it. It's not yours to use. You're entitled in New York, for New York beneficiaries, this doesn't apply to New Jersey, you're allowed to get an income stream. So any income that's earned you can get, but you can't get to the principal of it. So a lot of times we see people who will say, well, my cousin's mother went into a nursing home and they just transferred everything to the kids' names. And I always say, no, don't do that. Don't do that. Because what if the kids get sued? What if, God forbid, the kids die first? What if the kids are getting divorced? And beyond that, there's also tax ramifications. So the best bet, if you're going to prepare for that type of planning, is I always say the best bet is look into long-term care insurance first, where you can have control over what kind of care you get. And
that's planning early.
Planning early, getting your assets.
Compared to waiting until it's time.
Right. And this is so critical to get good legal advice for this type of planning, because once you transfer something out of your name, you can't get it back. And there are a lot of times, we see so many times that people make mistakes, and they're very costly mistakes. They're taxable mistakes, or they give it to their son. We had an estate once where mom just put the house in the son's name, and forget about all the tax issues with that. But the son died first, and now the daughter-in-law owned the house, and mother-in-law and daughter-in-law did not get along. So daughter-in-law said, goodbye, it's my house now, I'm selling, please leave. And she didn't have a legal leg to stand on because the daughter-in-law owned the house. So you don't transfer assets until you speak with people. And like Beth said, now that retirement assets are the biggest piece of somebody's estate, always, if you're sitting down with an attorney to do Medicaid planning, make sure they know the whole picture, because you don't want to move everything into irrevocable trust, give up control over everything, and find out you never would have qualified for Medicaid anyway because your minimum distributions would knock you off.
And or your pension, because it is income as well. So you may not have retirement assets. You may not have a lot of retirement assets, but you may have a very nice pension, government pension, teacher's pension, and you won't qualify. And you did all that work and you won't qualify.
Right, so you always want to look at the whole picture, because for Medicaid, they look at your monthly income as well as your assets. And you may be able to give away your assets, but if your monthly income is too high, you may not qualify for that type of care. And look, after everything we saw over the last year, who would want to go? We didn't want to go into nursing homes prior to COVID, but you certainly wouldn't have wanted to be in one last year. So, you know, you want to do your planning well in advance that you can avoid even having to go into a nursing home. And that's by getting in-home care, usually through a long-term care policy.
I'm going to talk about powers of attorney and healthcare proxies, but it's getting late and I wanted to leave a little time for questions. But I do want to ask the one crucial question that might be a crucial question, and that is, will the change in the president in the White House impact estate planning documents? And you want to be aware of any changes that President Biden may have already discussed. That doesn't mean it's going to happen because you have to get things passed, right. But are there any changes that have already been discussed that we should be aware of?
Yeah, so there's two big changes that we may see under the new administration. The one being that when President Trump took office, he essentially doubled the federal estate tax exemption. So today the exemption at the federal level is 11.7 million, which means probably, I know for myself and probably most people on this call, they say 11.7 million, I don't have anything to worry about.
Person. So if you're married, double.
Right, so it's double that. But Biden, the Democrats really want to reduce that. And 11.7, that's pretty much an all-time high other than when we didn't have any estate tax. But essentially, we're probably looking at that over the next 3.5 years, dropping by about half. If you were to look at the campaign, the Biden campaign, you know, it says they want to reduce it to $3.5 million. But most people feel that would be too difficult to pass. And that was really just a starting point for negotiations. But it could go down a lot. And keep in mind, even if Biden doesn't get any changes made because he just doesn't get to it or it doesn't get through Congress, the $11.7 million is scheduled to automatically sunset to about half in 2026. It was set up that way under the Trump tax cuts. So even if Biden doesn't make changes, we will automatically see that number come to drop by about half in 2026. The other bigger and probably more important change that we've been hearing about is right now we get what's called a step up in basis when somebody dies. So if my grandmother bought Apple stock for $10 a share years ago, and it's $1,000 a share at the time of her death, you get a step up in basis, meaning we look at all the assets and we give it a new basis based on what everything's worth the day somebody died. So that if I inherit that Apple stock and I sell it for $1,000, I don't have to pay any capital gains tax. I don't care that my grandmother paid $10. If she sold it while she was alive, she would have had all that capital gains to pay. So everything now gets a step up in basis. But what has been proposed under the Biden administration, and it's come up in past administrations, is get rid of the step up in basis. Meaning you can have an estate that's maybe only 500,000, maybe it's $1 million, maybe it's 5 million. It's not subject to estate tax, but almost everything in it will probably be highly appreciated. You know, just think about real estate. If you bought your house in the 70s, maybe you paid $30,000, $40,000, $50,000 for it, but it could easily be worth $500,000 or more today. When your children inherit that under today's rules, they won't pay any capital gains tax. But if we get rid of that step up in basis, they could have tax on $450,000 of gains. That would be huge. And the capital gains tax is actually way worse than the estate tax because it will affect everybody. And it can actually be more tax than the estate tax. So,
and that's part of what's happening is because they're talking about increasing the amount. Right now, capital gains tax is 15%, could even be 0 depending on your tax bracket, but it's 15%. And there's an extra tax the more income you make. But they're talking about making it in excess of 40%. 40% for capital gains tax. And if there's no step up in basis, that could be a huge amount of money. And that's capital gains tax can increase even if they don't take away the step up in basis. So that is something we're watching for and planning on, because if we do hear that capital gains tax is going away, now might be the time that if you were one of those people that bought GameStop, none of my clients better have bought GameStop, but if you were one of those people that bought GameStop and you actually still hold it, well, you may not have any capital gains by the time it's time to sell it. But if we go back to Apple and you still hold it, there could be a lot of capital gains taxes that you might have. And so we might have to sell early and bite the 15% bullet, or we might say, is this a stock that we're going to keep and hope that they do not get rid of step up in basis and then our children can inherit it? So there's going to be a lot of continuous planning, both estate planning and income tax planning with some of these new rules.
Right, absolutely. And I just want to throw in there, Beth, about powers of attorney, because I know a lot of times people are leery to sign them, but power of attorney is probably the single most important estate planning document somebody can have. Because without a power of attorney, that means if you're incapacitated, nobody can pay bills for you. Nobody can file your taxes for you. Nobody can, do anything for you, essentially. A power of attorney, even though it feels like you're giving over a lot of control to somebody, you're picking somebody you totally trust, but it would allow them to actually do a little bit of estate planning for you if needed. It could allow them to do Medicaid planning for you, get you on Medicaid, file your taxes, pay your bills. And all too often we get calls, my mom or my dad had a stroke, they're in the hospital. We don't know how well they're going to come out of it. There's all these bills, all this stuff has to be done. And without a power of attorney, your family's forced to go through guardianship proceedings in court, which nobody wants to have to go through those. It's expensive, it's time consuming, and it's the last thing you want your loved ones focusing on, because if you need guardianship, something terrible has happened. So you want to make sure they have a power of attorney. But I know even with Beth's office, once they're over a certain age, meaning the power of attorney, not the person, the banks and financial institutions don't want to accept them.
Many brokerage houses are using a 3-year time limit, even though they're durable powers of attorney that last forever. If they're over 3 years, they're afraid to use them because they're afraid maybe there's another power of attorney hiding somewhere else and the wrong person is coming to get the money. So there's a waiver you can sign that says, no, this power of attorney is still in effect. But if that waiver hasn't been signed, that power of attorney can be just thrown in the garbage, even though it's a good power of attorney. But there's one other problem. Many banks won't even use the power of attorney that the licensed, perfect, wonderful estate attorney wrote. They want their own power of attorney. And they won't even look at the real power of attorney. They'll say, no, this power of attorney isn't by Chase. We don't want it. So you have to be very, very careful.
You have to be careful. Thankfully, New York actually just passed a law until June, and it's supposed to have a little teeth to it, basically saying banks and financial institutions have to accept these powers of attorney, and we're going to penalize you if you don't. But it gives them an out. It says, well, if there's a good reason, if you can give a good reason why the bank isn't allowing the power of attorney. We don't really, this hasn't been, it doesn't take effect until June. We haven't seen how it plays out. So we tell clients you should always update your powers of attorney every 3 to 5 years. Again, just to make life easier for your family members, because if you're using a power of attorney, usually something's gone wrong. Somebody's gotten very ill. So you want to have those as up to date as possible.
Okay, so now I'm going to open it up for questions. We still have 10 minutes and I don't like to go over, but I wanted to open it up for questions. So if you have questions, we're going to do it by the, honor system or cordial system, where if just unmute yourself and ask your question. If somebody else is talking, just wait a moment and wait for them to finish, and then you can go ahead. And as I said in the very beginning, if you're afraid to ask your question out loud, put it in a chat to me, and I'll be watching the chat, and I will read out loud any questions that somebody might have that they don't want to ask themselves.
So Beth, this is Mimi. I have a question about this step up in basis.
Oh, so that's who my phone is. Hi, Mimi.
So if they do away with the step up in basis, what's the alternative? Should I have property? Should that be put into your children's name so that they'll already be on the deed?
Well, no, I'll take a stab at that first. Not necessarily,
Okay.
because when you add somebody's name to a piece of property, you're effectively giving that to them now. And we still still have step up in basis. So we're not saying it's definitely going away. It's just something that might happen. But again, if you add your children's name to a piece of property, it's now, and let's say your son gets sued because he was in a car accident and it was his fault, you may be saying goodbye to that piece of property, or have a new partner in it because your son has lost it to a lawsuit, a creditor, divorce, or something else. So
right.
But you're also gifting it.
Right.
So you're using up part of your estate taxes potentially, because you're giving it as a gift. So
right. You'd have to file a gift tax return to show that gift was made.
Okay. So
the other thing is, the other thing is, it might, if they are talking about getting rid of step up in basis, and they're talking about raising the capital gains tax, it might pay to look at, maybe it's time to sell it and pay a lower capital gains on it in your tax bracket than your children's.
Sell it to your children.
Well, you could do that
You
too.
still want your children to have it, yeah.
Right, but you'd have to sell it to them at fair market value.
Market value.
You know, I always get, well, if I sell it to my kids for $100, that's a gift. That's not a sale, that is a gift.
But you can sell it to them for fair market value, and then leave the money in your estate and leave the money to them in the will.
Right, give it back to them.
Okay, I just wondered, that's about all I really have to worry about is my property.
Okay.
Are there any other questions? Let me look if there's anybody. No chat questions.
Okay.
All right. So then I'll ask one more question, because we did talk about durable powers of attorney, but we didn't talk about healthcare proxies. And healthcare proxies is another thing that's absolutely crucial. And today, I mean, the first time you came into my office and you had that long list of, wait, it's not just a healthcare proxy, it's all of these other forms. Mm-hmm. So that if you have an old will, it's all of these other forms that we didn't have. So just go over to the what, in addition to the healthcare proxy, that you would also include in documents.
When it comes to the healthcare side of things, we do 3 documents in our office, actually 4, but I'll explain. So the healthcare proxy, that's a simple document that says, who would make medical decisions if I couldn't make them myself? And that could just be, I'm in the hospital, I'm having my appendix out and I'm under anesthesia, and the doctors come out, they say to my husband, Ian, everything looks great, we got that appendix, but Courtney's gallbladder looks terrible. And we should really take that out right now so she doesn't have to go through another surgery a month from now. My husband, as my proxy, could give them permission to do that. So it's not necessarily end of life decisions, but it's you naming somebody who would make medical decisions for you only if you couldn't make them yourself. The second document is a living will, and that has to do with end of life issues. Who would make those decisions if I couldn't make them myself? And this became a sort of a hot topic during COVID, because some living wills, not ours, but some living wills prohibited being put on ventilators. And now all of a sudden we had COVID and people needed to be on a ventilator. It was life, it was to keep you alive and bring you back to where you were pre-COVID, not just necessarily life-sustaining, meaning keep you on a ventilator, you know, for your entire life. So if you have a living will, you want to make sure it does not prohibit ventilators. But essentially, again, the living will allows somebody to make those end-of-life decisions based on what they feel you would have wanted under the circumstances. The third document is a HIPAA authorization, and HIPAA has to do with all of the privacy rules. So again, during COVID, we saw the importance of having this document because spouses and children weren't allowed to go into hospitals with their loved one. So they needed to have access to information. So being able to talk to the doctor, get information, especially if you have an older parent, like when my grandmother was still alive, she couldn't hear on the phone, even just to make appointments and find out information. You want to have that HIPAA authorization. Then what we do with those three documents is we register them with Assuring Your Wishes, which is part of hospice in Rockland, but essentially they put them on their database and you get a password and a username. So no matter where you are, whether you're at Good Sam, Nyack, Columbia Presbyterian, or, you know, hospital in Los Angeles or Florida, if you don't have the documents with you, you can instantly access them even on your phone, or your agent can access them on the phone for you. Because if there's an emergency, if you're racing to the hospital, you're not saying to the ambulance driver, oh wait, can you turn around and go back home? I forgot my proxy at home. You know, or if you're going from work or a restaurant or you're traveling, you want to make sure you have those healthcare documents.
Remember, all my clients, we have a copy of all your legal documents, but especially your healthcare proxy on a wealth management system that you can access by your phone.
Right, perfect. And out of all the legal documents you do, having access to the healthcare ones are the most important, because a will, it's not going to be used right away. A power of attorney isn't even going to be used right away. But that healthcare proxy, you may need that, or that HIPAA, you're going to need that on the spot when you get to the hospital. And these are really important that we say to clients, if you have a child who's 18, you want to have these documents in place for them, because at 18, you no longer have not only do you not have a say in their healthcare, but you can't even talk to them. And we had a friend who her son turned 18. She took him out to breakfast, and at breakfast, he had a seizure. Had never had any seizures in his life before. And at the table in the restaurant, he suddenly collapsed and had a seizure. Thankfully, she was a nurse and knew what to do. But she called me the next day and said, I'm at the hospital, nobody would talk to me. And they said, well, he's 18. And she said, he's turned 18 5 minutes ago. She said, I couldn't get any information. So as soon as he got out of the hospital, they came to the office and signed these healthcare documents. It's so important. You know, when my daughter will be turning 18 and going off to college, when she wakes up on her 18th birthday, before she opens up her presents, she's going to be signing these healthcare documents.
And I can see by the names, I have some of my clients here that do have young adults, children, and you should make sure, even if they're married, you should still make sure that they have the healthcare proxy and the power of attorney. It may not be so necessary for them to have wills because they may not have really much estate, but the healthcare proxy and the power of attorney is essential.
Right.
So I wanted to not go over. So I just wanted to tell everybody, thank you all for joining in with us. And thanks, Courtney, because she really is
thank you for having
so much
me.
knowledge in these issues. I'm going to ask Courtney to give her website again in case anybody wants to go on their website or email. Give your email address as well so that they can
Sure.
email you any questions, because as we said, this is general information, not specific to you. So why don't you give your email address and your website?
Okay, so my email address, it's a bit of a mouthful, but it's C like Courtney, Boniface, B as in boy, ONIFACE at caneboniface.com. So CANE Boniface.com. And I'll put it in the chat to make it easier. And then our website is caneboniface.com. Let me make sure I have that. And you can even email us. There's a contact us. You can put in your information and we'll get an email saying, you know, please call me, I have a question. And our office, I mean, with all of the snow and whatnot, I feel like we're open, we're closed, we're open, we're closed, but we're checking our messages. We're still working remotely when we're not actually in the office.
And all of you guys, well, most of you guys, you know me, you can call me at any time, but there's a couple here that are not my clients. So I'm just going to let everybody know that you can give me a call at my office, which is 845-627-8300, or look at my website, easternplanning.com, or send me an email at bblecker, BBLECKER, at easternplanning.com. So again, this has been recorded. If you want to listen again, we'll have it up on our website. If you thought there was some information that one of your friends or family might want to hear, we can send it to them, or you can send them to my website, because it will be up on my website probably, if Nicole's good, so probably tomorrow, but within the next couple of days. So thank you all for spending this time with us. Thank you, Courtney, and we'll see you soon, maybe at our St. Patrick's Day bingo. We're coming up with the terms for the St. Patrick's Day bingo. So if anybody has any specific St. Patrick's Day terms that they want us to use on the bingo board, email Nicole. Okay, we'll see you all soon. Bye-bye.
Good night, and thank
so
you.
much.
Thanks
Stay
so
well,
much.
everybody.
Thank you, Beth.
Welcome.